Toastmasters, do you need a lawyer to make a will? Well, the simple answer to that is no. Now, if you have a lot of money or your situation is complicated, let's say you want to make sure that if you don't have a spouse or you don't have children, that greedy nephew doesn't get your money until he marries that floozy, then you might want a lawyer just to make sure that people don't misunderstand what you're trying to tell them. But most of us, we're just trying to make sure that our loved ones are taken care of after we pass on. So most of us really don't need a lawyer to make a will. You may have already known this, and I apologize if I'm giving you information you already know, but some people are really not quite sure what to do first, how to go about actually making a will. Now, first off, sorry for my impromptu PowerPoint. First off, a disclaimer is in order. I am not a lawyer, not yet. I am simply a law student in training that I have actually taken what you call a decedent to the states class or wills class, and I've taken lots of notes in there, actually passed the exam. I don't even remember what grade I made. So I can give you some pointers, some guidance, but I can't give you advice. But this is the best advice you'll get because right now it's free. So there you go. Before I start too, I want to give you some definitions. And these are just definitions that you might want to mention in conversation to people so they'll be impressed, because these are words that lawyers use that out of context nobody uses these words. And I've actually given some handouts there, and maybe they'll pop up on the handouts. I didn't give the definitions on the handouts, I apologize. But if you didn't get one, then I'll make some more for you. But the first word is decedent. A decedent is simply a dead person. You will never hear that word on Law and Order. It is just a word that is used in the context of wills. The next one is testator. A testator is a person that makes a will. Again, only a lawyer will use these words. Holographic will is a handwritten will, and we'll talk about that for just a split second. And then nuncupative will is a will that is a deathbed will, or something that someone says before they pass on. All of these are valid wills, and I'll talk about the requirements of those. But the best will is an attested will. And attested simply means it is witnessed, that someone has written it down in this witness. So first off, let's talk about that, because that's the best kind of will to have. And you'll find will requirements in our general statutes, North Carolina general statutes. The state actually tells its citizens how to make wills and what requirements to follow. So it's not a federal law, it's actually state mandated. And our North Carolina statutes, and that's on the handout, Chapter 31, and it's section 3.3 talks about attested wills. Now, you may need a lawyer, or at least a lawyer in training, to help you understand the language. So when I boil it down, basically it is that an attested will must be in writing. It has to be signed by the testator. Okay, what's a testator? The person that makes the will. And it has to be signed by two witnesses. And those witnesses have to attest to the testator's signature. Say that 5 times fast. So, but the witnesses don't need to be with each other. They can sign at different times, but there has to be two. So those are the requirements of an attested will. So if you don't know where to start, what do? And I'm going to point you out some legal sites, and this is not a definitive list for sure, and those are listed on the handouts I gave too. The first one is LegalZoom.com, and if you've ever even thought about starting a business or making a will or maybe even doing a prenup or something like that, LegalZoom has some great resources for legal sites, legal information that you can use later, and it has a section on wills. So LegalZoom is one of the websites. Then there's Nolo.com, which I found that by accident just Googling. And the last one is Law.com. And Law.com has a lot of information as well beyond just making wills. It has information for all kinds of legal resources that you could turn to without going to a lawyer first. So it saves you a lot of money. But let's say that you have one of those other type of wills. You don't have an attested will. Maybe you found, maybe your grandmother's house, a holographic will. Something that a loved one wrote out that they wanted their resources or their goods to go to someone, well, our general statutes cover that. What has to happen in the holographic will, however, since I don't really suggest that you try this one, is that it has to be in the testator's handwriting, first off, and there has to be 3 witnesses that attest that that's that person's handwriting. So maybe 3 relatives who receive letters or checks or that sort of thing, so they can compare the testator's handwriting and make sure that's their handwriting. And also, the testator, of course, must sign this. So there are a lot of interesting cases where they found handwritten wills on items you would never even imagine. There was one guy who got trapped under a tractor, and he knew that he was dying, and so he wrote underneath what he wanted to have done with his estate. And it held up in court because they knew that was his handwriting and they knew the context of the situation. So I don't recommend it, but it can happen. And then there is what I referred to earlier was the nuncupated will, which is the deathbed will. And that'll stand up in court, but there are very strict requirements. First off, the testator, the person saying the will, has to be on their deathbed. They literally have to die from their illness. So they have to know that these are their last days. Perhaps they haven't been taking care of their wellness very well, and they know, or they receive their doctor tells them they only have a few limited time to live. So, and there has to be 2 witnesses that are there that hear this person state these terms. So, like I said, don't really recommend you waiting to the last minute. But if you do, what happens in that case? The state actually has a statute that tells the probate court what to do with your estate. They will, under General Statute 29, it talks about how it will be going down. It's very complicated. But first off, what happens is if you have a spouse, it goes to your spouse. If you have a spouse and children, it is fractioned off depending on how many children you have and that sort of thing. If you don't have a spouse or children, it goes to your parents and then to your grandparents. So it's very, very good, and it goes way down to even descendants as far as brothers and sisters, aunts and uncles and that sort of thing. So if you forget, it's not the end of the world. Your goods will be portioned out according to your family. So last but not least, if you have a very complicated situation and a lot of money, I do recommend you getting a lawyer. But if you want to save some money and you have a very simple situation, then you can make your own will using the forms on the website, or you can go to a lawyer in training even and get some guidance. Thank you.